Am I audible to everyone?
Yes, sir.
Good afternoon to all my senior colleagues, my dear friends, and all the dignitaries. Here, I am delighted to share my experience as well as whatever written in code to all my friends. And the topic is very useful and very, you know, it require a lot of discussion on this topic. So I hope this will be an interactive session. Not like that I will be speaker and you will listener. This I don't like. So I think you all have to participate, and the session must have lively, So I hope you all are here to exchange of some views also. If it require anything in between our session, anybody can intervene and provide their feedback or some suggestion like this. So it does not mean that you can have to wait till the last last hour of session. That is person answer session. Anytime you may intervene, you can share your suggestion. Okay. So let's start. Just a moment. Hi, myself Ranjeet Verma, and I am seeking your permission to start this topic, commercial wisdom CoC. Right? Right, sirs? Am I audible to all?
Yes, sir.
Okay. The topic is usually very vast and very, even the various court has a different judgment. So let us start from the root cause of this act, why this is important to enact Insolvency and Bankruptcy Code of India. First of all, this. So we have a different types of laws and forum where can we approach for the our recovery of our dues or present our case. But in 2000 decades and after that, NPA has increased tremendously in India. So government thought to establish a code where can we have a complete solution of this NPA and other things. And moreover, the economists demand that the industry should be a healthy one, not a sick one. So how can we revive that industries from a process as well as address to the investor and the banks? Okay, there are three parties. First of all, the industries, second bank, and third is investor. So these three leads to the thought of providing some additional way of providing relief to the stakeholders, right? Now about the act. This an act to consolidate and amend the laws relating to reorganization, that is financial structure, you can say, and insolvency resolution of corporate person. Everybody know about corporate person. Okay, partnership firm and individuals in a time-bound manner. Here the point is that all other act which have no time limit. दो साल लगते थे, 3 साल, 5 साल, 10 साल लगते थे, कोई लिमिटेशन नहीं था. But this act is a very useful thing is that the act is time bound and every stage there is timeliness, timeline guidelines. आपको 7 दिन में करना है, 7 दिन में करना है, 15 दिन में करना है, 15 दिन में करना है. So providing timeline is the main benefits of this code. And second is maximization of value of assets. How can we maximize the value of assets of not only the stakeholder, also the corporate debtor also. Okay. Including alteration in the order of priority of payment of government dues and to establish an insolvency and bankruptcy board of India. Now, we have to establish a board which will govern and regulate the insolvency proceeding also. And where? This is from Insolvency and Bankruptcy Code, right? Now, the purpose of introduction of Insolvency and Bankruptcy Code is to ensure that company continue as going concern. Now, this is main thing. The purpose is not to recovery of dues. आपको ये नहीं है कि अपने पैसे dues है आप recovery कर ले वहां से. This is not a system to recover the dues, but the system is to ensure that company continues as going concern. Now, the second part is efficient management. This is the main thing. Why company fall? Why company seek? The first thing is most of the cases, management is not efficient, not thoughtful. There is no vision of the management. Only one vision कि मुझे business चलाना है, run करना है, establish business. But there is no vision for the broad aspects of business. Okay, so without a vision, company cannot sustain its goal. So if a company has inefficient management, the alternate source is that to provide a professional who have a vision, and we can regulate this company so that the company continue as going concern and effectively discharge its obligation, not only financials but other obligation also, some social obligation also. Everybody is okay with this? You're looking with Dr. Rajas Boras?
Yes, sir.
So is it right or something you want to add?
Sorry?
Something you want to add in between that?
No, sir.
Okay. So efficient management take over the management of the company. Everybody knows who works efficiently and clear all burden of creditors' dues. Now the problem is the code is often misutilized by various stakeholders and even by committee of creditors. That is why now the question is arise, what is the limitation of this wisdom of CoC? How the CoC can get without having any laws and regulations? Means everybody was regulated. RP was regulated and all professions are regulated, but CoC was not regulated. There was no regulation to provide any guidelines for CoC earlier that. So there is a number of cases at NCLT, NCLAT, and of course Supreme Court. We will discuss later. So that is why now one thing is that technical aspect. Second is some legal aspect, and third is most of this commercial wisdom of CoC, commercial aspect, financial aspect, right? So this is the part we are discussing about commercial wisdom of CoC. Now, before enactment of IBC, we have a BLRC report. Bankruptcy Law Reform Committee report. The limited liability company is a contract between equity and debt. A company is not only limited liability, every company has two types of financial structure. One comes from equity and second comes from debt. As long as debt obligations are met, debt obligation means either from banks or financial institutions or from private funding, anywhere else. Equity owners have complete control. No problem. We are running management and we are repayment of duties, debt is on schedule time. So everybody is happy, company is happy, staff happy, everybody is happy. Unless until debt are repaid in time. And creditors have no stake in how the business is run. Nothing to say. This is the tradition of India. I don't know about world, but this is the tradition of India. अगर आप पेमेंट आते रहा हमारा टाइम पे हमारा इंटरेस्ट भी आते रहा, there is no problem. आप रन करिए कंपनी को. No interference in the business of the company until and unless we default in the payment of our dues, financial institution dues. When default takes place, control is supposed to transfer to the creditors. Equity owners have no say. This is the report from BLRC. This is not how companies in India work today. For many decades, creditors have had low power when faced with default. Means creditors know not much opportunity to deal with the financials default of the subsidy corporator. Promoters stay in control of the company even after default. Only one element of a bankruptcy framework has been put into place to a limited extent. Banks are able to repurchase fixed assets which were placed with them. Mostly bank never grant any loans without having any security or pledge. While the existing framework for secured credit has given right to bank, some of the most important lenders in fact are not banks. They are the dispersed mass of household and financial firms who buy corporate bonds. The lack of power in the hands of a bondholder has been one reason why the corporate bond market has not worked. This is from BLR's report. Thus, in turn, has far-reaching ramifications such as the difficulties of infrastructure financing. Under these conditions, the recovery rate obtained in India are among the lowest in the world. When default takes place, broadly speaking, lenders seem to recover 20% of the value of debt as on NPV basis. Means NPV rises. As I already told, that due to NPV rises, it leads to think that we need a law which deals this and provide the solution for all this NPV-like problem. Under this concept, when creditors know that they have weak right resulting in a low recovery rate, they are averse to lend. Means they always hesitate to lend their hard-earned money or their money to the corporates. Hence, lending in India is concentrated in a few large companies that have a low probability of failure. Means right now the MSME or like this or a small company, small medium companies have always liquidity problems. Further, secure credit dominates as creditors' rights are partially present only in this case. Only those have assets and properties have more money and investment, and those don't have any assets or properties. the lenders have always hesitate to lend them. Lenders have an emphasis on secured credit. In this case, credit analysis is relatively easy. It only requires taking a view on the market value of the collateral. As a consequence, credit analysis as a sophisticated analysis of the business prospects of a firm has revelated. Both these phenomena are unsatisfactory. In many settings, debt is an efficient tool to corporate finance. Three, there needs to be much more debt in the finance of Indian firms. More debt required for the growth of the company. If you want to grow up the company, or want for some projects to be growth and run efficiently, we need a lot of finance. When a firm defaults, the question arises about what is to be done. Many possibilities can be envisaged. One possibility is to take the firm into liquidation. Another possibility is to negotiate a debt restructuring, where the creditors accept a resolution of debt on the NPV basis and hope that the negotiated value exceeds the liquidation value. Another possibility is to sell the firm as a going concern and use the proceeds to pay creditors. Many hybrid structures of these broad categories can be envisioned. The committee, BLRC committee, I think, believes that there is only one correct firm for evaluating such possibilities and making a decision. A creditors committee means CoC, where all financial creditors have voted in proportion to the magnitude of debt that they hold. In the past, laws in India have brought arms the government into the questions. This has been strictly avoided by the committee. The appropriate disposition of a defaulting firm is to business decision and only the creditors would make it. अब एक कंपनी है, कंपनी सीख हो गई, कंपनी बिकम सीख. क्यों सीख हुई? There is a 2 or 3 reasons. First is that management is not efficient. Second is that company has liquid fund crisis. Third is that company is not regulated. So अब इसमें क्या करेंगे, कंपनी को कैसे रिवाइव करेंगे? तो जो efficient, we replaced efficient management professionals, insolvency IRP, means IP, insolvency professional, to the management of this C company. And second, for financials, we have a CoC who will run the management, run the financial aspect. And third is regulated by our NCLT. And fourth one is by our own IBBI, who will provide all records and documents to the particular party. Now here committee of creditors, because if we want to study about the wisdom of commercial wisdom of CoC, we have to learn all these things. I know all participants are very learned people, but this is my duty to take all these things. Now the committee of creditors. So applicant, either it's a financial creditor or operational creditor, file application to the NCLT about their dues, and right now which is more than 1 crore, and their application accepted, and one insolvency professional appointed as IRP. The first duty of the IRP to the interim resolution professional shall, after collation of all claims, invite all claims through forms, you will know. So the interim resolution professional shall, after collation of all claims received against the corporate debtor CD and determination of the financial position of the corporator, constitute a committee of creditors. Means, first of all, receive claim, scrutiny of claim, everybody know about that. Receive claim, scrutiny of claim, and then categorize the claim as per their respective dues. So, and after that, IRP constitute a committee of creditors. The committee of creditors shall comprise all financial creditors of the corporate debtor. Needless to say anything about this. Subject to subsection 6 and 6A, where the corporate debtor owes financial debt to two or more funds, this is not part of this. The committee of creditors shall have the right to require the resolution professional to furnish any financial information in relation to the corporate debtor at any time during the corporate insolvency resolution process. Anytime CoC may ask IRP to furnish any information required for that CD. Now, approval of committee of creditors for certain cases, actions. Certain thing which is the ambit of the CoC, I am just reproducing this. What is the ambit of CoC, which is have to cross through CoC? So, notwithstanding anything contained in any other law for the time being force, the resolution professional during the corporate insolvency resolution process (CIRP) shall not take any of the following actions without the prior approval of the committee of creditors. Certain items which require the approval of CoC. First is raise an interim finance in excess of the amount as may be decided by the committee of creditors in their meeting. Company needs finance. Sometimes it has own finance. Sometimes CoC provides some finance. Sometimes it required to finance from outside this financial institutions like banks or some other. So in a meeting, CoC provides some limits to finance and some terms and conditions. Accordingly, they have to get finance from banks or outside institutions. But whenever we want to cross that limits, we have to get fresh approval from CoC. This is first part. Create any security interest over the asset of the corporate debtor, right? Change the capital structure of the corporate debtor. Means if you want to issue some capital or some debt, this leads to change the capital structure of the corporate debt. So which is only allows after the approval of CoC. Here whole word is change the capital structure of corporate debtor, including by way of issuance of additional securities, creating a new class of securities, or buying back or redemption of issued securities. In case the corporate debtor is a company, here we are discussing about company only. Record any change in the ownership interest of the corporate debtor. Matlab, you cannot change the interest of the ownership of the debtor unless and until CoC approve this. Give instruction to financial institutions maintaining accounts of the corporate debtor for a debit transactions from any such accounts in excess of the amount as may be decided by the committee of creditors. Clear? Undertake any related party transactions. Now, this is very wide term and required to study about related party transactions. So normally in practically RP or IRP declare that certain items or certain transactions are through related party, amongst related party transactions. So which one is declared as a related party transaction, and RP wants to involve in their transactions or do some transactions, they have to go for CoC approval. Without CoC approval, they cannot do any transaction which have a related party involvement. Amend any constitutional documents of the corporate debtor, right? Delegate its authority to any other person. Delegation is not allowed, but only after CoC approval. Dispose of or permit the disposal of shares of any shareholder of the corporate debtor or their nominees to third parties. Make any change in the management of the corporate debtor or its subsidiary. Not only this, their subsidiary also. If any action leads to the change of management of the subsidiary also, they have to go for CoC approval. Transfer rights or financial debts or operational debt under material contracts otherwise that in the ordinary course of business. Make changes in the appointment or terms of contract of such person specified by the committee of creditors. Already specified जिसको किया हो उसका चेंज करना चाहते हैं तो आपको CoC. Now make changes in the appointment or terms of contract of statutory auditors or internal auditors, the corporate auditor. You cannot appoint internal auditor or statutory auditor or cannot change their terms and conditions as already specified in the earlier CoC approval unless and until it is again passed by CoC. The resolution professionals shall convene a meeting of the committee of creditors and seek the vote of the creditors prior to taking any of the action under subsection 1, right? No action under subsection 1 shall be approved by a committee of creditors unless approved by the vote of 66% of the voting share. Where any action under subsection 1 is taken by the resolution professional without seeking the approval of the committee of creditors in the manner as required by this section shall be void. The committee of creditors may report the action of the resolution professional under subsection 4 to the board for taking necessary action against him under this code. Now the very thin area, different area distributed to some different professional. Resolution professional को दिया गया कि आपको मैनेजमेंट संभालनी है. You have to take over the management according with the rule and regulations provided under this code. CoC को दिया गया कि आपको जो है फाइनेंस देखना है, कमर्शियल देखना है आपको, और जो आपका राइट है वो ऑलरेडी आई टेकन. दिस इज द एम्बिट ऑफ CoC. अब लॉ का क्या रोल है? एनसीएलटी का रोल है कि जो रेगुलेशन है उसको सही से किया जा रहा है कि नहीं, और टाइम टू टाइम जो है रिपोर्टिंग एज अ as a watching of this all regulations, rules, acts provided under insolvency. So nobody can cross any limit area to another one. Nobody can overlap any the right of or provided in act to of the other two. Suppose that whatever provided for CoC, that is for CoC only. RP cannot add that power provided to CoC. And what is power provided to RP, that CoC cannot interfere. And the same thing is that NCLT also double applicant executing authority double A should also act accordingly. He has to do all act, provide all order, but under the regulations and of this IBC. Now comes the main theme: decoding commercial wisdom. Already I had provided that the formulation of the doctrine of commercial wisdom of CoC by the Supreme Court is based upon the report of Bankruptcy Law Reforms Committee, BLRC. The court in India initially interpreted the doctrine of commercial wisdom of the CoC as a principle of non-justificability. Okay. As a result, the courts granted high judicial deference to the commercial wisdom of the CoC. Now, what is normal decision making and commercial decision making? There's been two things. Now we can discuss one major case which clear out confusion about the difference between other acts and the commercial wisdom of the CoC. And the case is Ram Krishna Forgings Limited versus Ravindra Lunkar. He is a resolution professional. The fact of the case. ACIRP was initiated against ACIL Limited. ACIRP was initiated against ACIL Limited based on the application of IDBI Bank. Means IDBI Bank was applicant for the CIRP. Their application accepted, and then ACIRP was started for ACIL Limited. The appellant was resolution professional. Sorry, resolution applicant means who have involved in who have provided the resolution plan. Submitted the first resolution plan. They submitted the first resolution plan, and payment of the fees 63.5 crores to FCs, financial creditors. After the publication of expression of interest by the RP, okay, after several negotiations, an addendum was submitted to the resolution plan with a raise of payment to the FCs that was 73 crores and 80 lakhs. Earlier it was 63 crores and half crores to FCs. 63.5 crores earlier. And after that, this was revised to 73 crores and 80 lakhs. Revised plan was submitted by the appellant, and later on the final resolution plan was submitted. Okay. It further provided that the proceeds to the particular land will also go to the FCs. Means not only this amount, the proceeds of the land will also goes to FCs. CoC approved the plan as per the procedure. The approval plan was moved before the AA as per Regulation 31 and of the code. NCLT gave the order which led to abeyance of the resolution plan, wherein it abeyance means hold. Means NCLT gave the order which led to abeyance of the resolution plan, wherein it directed the official liquidator to provide the exact value of the assets. Now the main story comes here. NCLT just overrided the power of the CoC and appoint a person which was not appointed by the CoC. Means they appoint oil of the government official liquidator to provide the value of the assets. Now the appeal, of course appeal तो होना ही था, तो appeal किया गया वहाँ पे एनक्लेट में. तो 61 में अपील होता है, ब्रनो. So now appeal made under section 61 report. Enclave पे गया. Upheld the orders of the NCLT. Enclave ने कहा कि नहीं, NCLT जो कहा है वो सही है. Means NCLT was right. अब क्या करे? तो अब गया 62 62 Supreme Court. So little, I think everybody little understand Hindi. If any person has objection, so there is, because I will use a little Hindi also. So I hope everybody understand little Hindi. So ठीक है, मैटर पहुंचा सुप्रीम कोर्ट. अब इशू बिफोर, अब इशू क्या था? इशू, देयर इज टू इश्यूज. One issue is that already resolution application was approved by CoC. Now NCLT interfering that कि नहीं नहीं आपका resolution गलत है, इसका फीस वैल्यूएशन कराएंगे. तो वैल्यूअर अपॉइंटमेंट का राइट किसको है? CoC को. So now this right also interfering NCLT. And second thing is कि आपको जो है फाइनेंशियल विजडम है, कमर्शियल विजडम है to decide whoever the resolution applicant, तो उसको भी राइट कर रहे थे NCLT. Let us see or the Supreme Court judgment. The appeal was allowed. The orders under challenges were set aside by the Supreme Court, and the Supreme Court did not remand the plank back to NCLT as it will lead to impediment on the objectives of the court, weak and time-bound resolution. And HC directed NCLT to pass relevant orders within 3 weeks. So आप इसमें और भी जजमेंट है. इसमें ये तो शॉर्ट है. इसमें तो ये था कि आपको आप ये यहाँ पे चैलेंज एक्सेप्ट किया गया था वहां पे, और सुप्रीम कोर्ट ने ये कहा था कि जो those commercial wisdom of the CoC always to be maintained, and NCLT has no right to interfere in this matter. So जो उन्होंने जो ये अपॉइंटमेंट किया था उसका OL का, that will be set aside. आप अपॉइंटमेंट नहीं कर सकते हैं, आप इसको आप बाईपास नहीं कर सकते हैं. जो पावर है CoC को आप बाईपास नहीं कर सकते. You cannot bypass the power of the CoC. So then sent again back to the NCLT to decide as per the code of the IBC. आप मैक्सिमम ये कर सकते हैं कि आप वापस भेजिए CoC को फॉर हिज कंसिडरेशन, बट आप खुद अपने आप डिसीजन नहीं ले सकते हैं. दैट इज मेन थीम ऑफ द एक्ट. आप वापस भेजिए, आप डायरेक्शन दीजिए आरपी को, CoC को, बट यू कैन नॉट टेक एनीथिंग फ्रॉम योरसेल्फ. नाउ लेट्स गो. The committee of creators, this is, I think, this is the committee of creators hold a determined position in the CIRP, as it is subject to the commercial wisdom of CoC to decide whether corporate debtor is to be revived or liquidated. There is two this area: either go for revival of the company and get some resolution plan, and if there is no resolution plan or those resolution plan which is not approved by CoC, so the last option is to liquidate the company. It is a heterogeneous body made of financial creators having varied interests. The CoC is solely responsible for actions and decisions according with section 28(6) of the code. As above mentioned, the approval threshold by CoC under section 34 showcases the power of CoC is in determining the fate of corporate debtor. Hence, it is undoubtedly clear that the commercial wisdom is a substantial factor which needs to serve the purpose as emailed in preamble of the code. Now, The Supreme Court in SR Steel Limit India versus Satish Kumar Gupta emphasized that the CoC must account for the interest of all stakeholders while finalizing a resolution plan. The absence of any concrete delimitation of the CoC power puts those classes of creators who are not part of the CoC at a disadvantages. The increasing prevalence and magnitude of haircuts. Everyone understand about haircuts, I think. So the increasing prevalence of and magnitude of haircuts, albeit an improvement from pre-IBC days, could lead to more difficulties for creators. Haircut is very painful, really, because if we have a dues of 100 rupees, and instead of giving more than 100 rupees, we are getting some 10 rupees or 20 rupees or 30 rupees in turn. So this is very painful. And this painful arises on Videocon industries cases. This is the leading cases where the question arises about the haircuts. The claims of the secured financial creators took a haircut approximately 96%. While the claims of operational creators took haircuts of around 99%. Oh my God. Furthermore, because the IBC is a relatively new legislation, judicial interpretation and innovation play an important role. In the context, judicial difference in the forum under unquestioning commitment towards upholding the commercial wisdom of the CoC is dangerous, not just vis-a-vis the corporate data itself, but also in terms of its implication for the wider economy. तो इसी केस में हुआ था कि CoC इज नॉट सुप्रीम और क्वेश्चन राइज किया गया था कि CoC पे रेगुलेशन क्यों नहीं है। फिर बाद में कई केसेस आए जिसको डिफाइन किया गया कि क्या बाउंड्री है CoC का, क्या कर सकते हैं, लेकिन इसने क्वेश्चन राइज किया क्योंकि 99% haircuts, 96% haircuts, so the CoC role should be also be regulated by the code. Now it's section 30 of IBC. We will go for case studies in last of this end of this slides. Now what is the role of NCLT adjudicating authority? Section 31, approval of resolution plan. If the adjudicating authority is satisfied that the resolution plan is approved by the committee of creators under subsection 4 of section 30 meets the requirement as referred in subsection 2 of section 30, it shall by order approve the resolution plan, which shall be binding on the corporate debtor and its price member creators. Means resolution professionals will put the resolution plan to the CoC. CoC will take this under section 30, and if she finds that all is okay, CoC will approve, either approve or reject. If CoC approve or if reject, the RP put forward this to NCLT, AA. And AA, if satisfied that all technical and regulation, legal terms is satisfied and fulfilled, and committee of creators has correctly approved that plan, then if there is no choice but to approve the resolution plan. And that plan will binding on the corporate debtor itself, its employee members and all creditors. No creditors can challenge that मेरा पार्टिसिपेशन नहीं था, मैं इसमें नहीं, मतलब ये गलत है, आप सही है। And that including central government also, a state government, local authority, to whom a debt in respect of the payment of dues arising under any law for time being in force, such as authorities to whom statutory dues are owed, current guarantors and other stakeholders involved in the resolution plan. One second. Provided that the adjudicating authority shall, before passing an order of approval of resolution plan under this subsection, certify that the resolution plan has provisions for its effective implementation. Means, before passing these resolution applications, the AA shall, before passing an order for approval of resolution plan under this subsection, have to satisfy themselves that the resolution plan has provisions for its effective implementation. मान लीजिए जैसे हमने वादा कर दिया प्लान में, जो कि पॉसिबल नहीं प्रैक्टिकली, हमारे पास पैसे नहीं, हम कहते हम 10 करोड़ दे दें, कहाँ से लाएंगे पैसे, या ऐसे कुछ हमने एक्शन दिखा दिया जो कि हमारे पास कैपेसिटी नहीं है, तो AA has to ensure that there is a possible effective implementation also. Whatever the plan provided and approved by CoC have possible effective implementations. Where the executing authority is satisfied that the resolution plan does not conform to the requirement referred to in subsection 1, it may by an order reject the resolution plan. अब देखिए यहाँ पे मेन मजा आएगा, अब अगर रिजेक्ट करते हैं वो, तो क्या करेंगे वो? He then asked the committee of creditors to and resolution professional to come for another plan. ये नहीं कि आप दूसरा प्लान अपने आप अप्रूव कर देंगे. This is the ambit of CoC. जब होगा CoC ही अप्रूव करेगा, आप नहीं कर सकते हैं. You have to go to the RP, direct RP to come for another resolution plan, and CoC has to approve another resolution plan and comes to the AA for approval. After the order of approval under subsection 1, earlier it was rejected. Now the one is approved. If that was approved, the moratorium order passed by the executing authority under section 14 shall cease to effect. मतलब जो moratorium लागू किया गया था वो आपके ऊपर से हट चुका है. You are free from moratorium. The resolution professional shall forward all records relating to the conduct of the corporate insolvency resolution process and the resolution plan to the board to the recorded on its database. Means we have a different form, everybody know about that. So we have to submit that under that form, and that is recorded under database of this Insolvency and Bankruptcy Board of India. The resolution applicant shall, pursuant to the resolution plan approved under subsection 1, obtain the necessary approval required under any law for time in force within a period of 1 year. The resolution applicant shall, pursuant to the resolution plan approved under subsection 1, obtain the necessary approval required under any law for time being in force. जो भी आपको करना है आपको एक्सेल में कर लीजिए आप, मतलब का ये करने मतलब है within a period of 1 year from the date of approval of the resolution plan by the adjudicating authority under subsection 1 or within such period as provided by in such law whichever is later. कई चीजें करना होता है, शेयर ट्रांसफर करना होता है, आप नीडलेस टू शेयर जो कमेटी बनती है, there is a process here, we cannot discuss all process, but after process होता है जब resolution plan effect मतलब approve हो गया and moratorium is ends, then RP will continue till 1 year or some extra time wherever required in other law. Provided that where the resolution plan contains a provision for combination as referred in section 6 and 5 of Company Act, the resolution applicant shall obtain the approval of the Competition Commission of India under the Act prior to the approval of such resolution plan by the Committee of Creator. Okay, means अगर आपको जरूरत पड़ेगा कि कंपटीशन कमीशन ऑफ इंडिया से अप्रूवल लेके आए, तो पहले हम लेके आएंगे तब यहाँ से करेंगे अप्रूवल. Now some foreign countries have some commercial wisdom of CoC. Singapore, the CIRP in India is for judicial management process in Singapore. Singapore, this is called judicial management process. There is a distinction in the formal name. However, it is akin to the CIRP in India. It is crucially under the control of a licensed insolvency practitioner. Called it the judicial manager. हमारे यहाँ बोलते हैं IRP, RP, इंसॉल्वेंसी प्रोफेशनल बोलते हैं. सिंगापुर में बोलते हैं इसको जुडिशियल मैनेजर. He takes over the front seat in the process. और यहाँ भी होता है ये तो. In the case of Lim Siu Su versus Sembawang engineers, it was held that the judicial manager's roles and responsibility are multifaceted. It means that the varied function in the name of company is now under the control of judicial manager. A distinction can be observed from that of the position in India. Same वहाँ पे आरपी है, यहाँ पे वहाँ पे जुडिशियल मैनेजर होता है. As in the letter, the function of RP and CoC are connected but well defined, whereas in Singapore, the judicial manager performs the function of the RP, including the means वहाँ पे CoC नहीं है, judicial wisdom जो है RP ही करते हैं. अब देखते हैं यूनाइटेड किंगडम क्या हो रहा है. मोस्टली लॉ टेकन फ्रॉम यूनाइटेड किंगडम से लेते हैं हम या विशेष लेते हैं हम मोस्टली. तो देखें यूके में क्या है. In UK, the Insolvency Act of 1986. Okay, इतना पुराना, हम तो बहुत पीछे फिर तो. The Insolvency Act of 1986 is in place where the insolvency process is called as administration. Objective of the act are similar to those in India, like rescuing the company as a going concern, providing results up to the creditors, maximization of the creditors of assets, and balancing the interest of all the interested parties. A wide range of powers has been given to the administrator. हमारे यहाँ आईपी बोलते हैं इंसॉल्वेंसी प्रोफेशनल, और इनके क्या हो गया, एडमिनिस्ट्रेशन हो गया. Who is under the duty to act in good faith and is impartial and independent in managerial affairs of the company. The creators can form a committee in order to, यहाँ देखिए यहाँ CoC होता है, हमारे सिंगापुर में नहीं दिख रहा था. The creators can form a committee in order to assist the administrator in performing his functions. Whereas when compared to India, the CoC is in driving seat. CoC हमारे यहाँ मालिक होते हैं और यहाँ असिस्ट करते हैं. That differences. And the RP performs the function of assisting the financial secretary. देखिए उल्टा हो गया वहाँ पे. हमारे यहाँ क्या होता है कि हम असिस्ट करते हैं, आरपी असिस्ट करता है CoC को, और यहाँ पे उल्टा है कि इंग्लैंड में, यूके में. यहाँ पे क्या है कि आरपी को सीओसी असिस्ट करेगा, आरपी हेड होगा, सीओसी विल असिस्ट द आरपी. A wide range of power has been given to the administrator, who is under the duty to act in good faith and is impartial and independent in managerial affairs of the company. The creditors can form a committee in order to assist the. ये तो हो गया already. Whereas, ठीक है. And the legislature of the UK has also provided the provision for challenging the code of administrator in case the practices go against the interest of creditors or in case of misfeasance. In the matter of Charnley David Limited, Charnley David Limited, it was contended that the company was sold at an undervalued price by the administrator. हमारे आरपी है, हमारे एडमिनिस्ट्रेटर है, तो उन्होंने कम पैसे में बेच दिया. वीडियो कॉन में 98%, 99% है. आई डोंट नो आरपी गलती थी, सूची की कहाँ थी, या कोई मिला ही नहीं. ऐसा तो होता होना नहीं चाहिए. एनीवे, तो यहाँ पे वही बात है, कम पैसे में बेचा गया, undervalued price by the administrator. It was claimed by the creditors that the administrator's actions are clearly a breach of duty on his part. Justice Millett held that the courts need not judge the outcome and decision with the benefit of hindsight. Accordingly, it was held that the price which was valued was the best possible as per the circumstances. There are a statement of insolvency practices in place for standardizing the conduct of administrator, liquidators, etc. मतलब कोर्ट ने कहा कि हो सकता है कि मतलब वही वैल्यू पे मिला होगा. आप कैसे कर सकते हैं कि ये उन्होंने जानबूझ के अंडर वैल्यू किया उसमें. इसमें केस स्टडी बहुत इंपॉर्टेंट होता है. वाला केस सबने देखा, वो जिसमें कहा गया था कि एनसीएलटी एनसीएलटी पावर नहीं है कि आप जो है आप प्रोवाइड करें पावर को, आरपी और सीओसी पावर को. अब इसमें कोटक इन्वेस्टमेंट का केस था, एक कोटक इन्वेस्टमेंट एडवाइजर्स लिमिटेड वर्सेस क्रिस्टल समारिया. ये भी एक सुप्रीम कोर्ट बहुत लीडिंग केस था. मैंने पूरा तो नहीं लिखा, इसमें ब्रीफ दिया है क्योंकि बहुत 140-50 पेज का वो ऑर्डर था. दिस वाज नॉट पॉसिबल टू ब्रिंग ऑल ऑर्डर्स अंडर दिस स्लाइड, लेकिन ट्राई टू एक्सप्लेन मोस्ट ऑफ द ऑर्डर्स. किसी को कुछ करना है? Anybody want to say something in between? It's very crucial subjects. Anybody wants to say something?
No, sir.
Okay. Fact of the case. RP by notification date 9 July 2018 invited expressor of interest, we call UOI. Can we take a break for 15 minutes? Azli ji,
Yes, sir.
can you take a break for 15 minutes?
Yes, sir.
If you can come on 3:15. 3:50 is okay?
Fine, sir.
Okay. You can come on, join up again on 3:50. Okay.
Till what time is the break? Any idea? Can anyone help me? Anyone from ICSI? Is my voice audible?
Yes, your voice is audible.
Sir, till what time is the tea break?
To 3:50.
Okay, thank you. Thank you.
Now let us start. Can I start? Am I audible?
Yes, sir.
Yes, sir.
Okay, please let us resume. Now we have a case of Kotak Investment Advisors Limited versus Krishna Samaria. RP White notification dated 9 July 2018 invited expression of interest UI to submit a resolution plan from interested resolution applicants. Okay, it's a 9 July. Who fulfilled the minimum condition, whatever in UI is stipulated in UI. As per the said UI, if any proposed applicant had any queries or clarifications, it was required to write to RP on or before 31st July 2018. ध्यान दिया जाए इस बात पे. 9 जुलाई का नोटिफिकेशन था, 31 जुलाई के पहले आपको कॉन्टेक्ट करना था. अब the EOI was required to be submitted via email on the email address of RP or via post at the address mentioned in the said invitation on or before 8 August 2018. आपको 8 अगस्त तक आपको कोई क्लैरिफिकेशन चाहिए तो 31 तक आप ले लीजिए, और अगर आपको 8 अगस्त तक आपको सबमिट करना था. On the said date 9 July 2018, analogously the first form G also come to be notified. ठीक है, form G notified हो गया. While the said form G, the last date prescribed for submission of resolution plan was on or before 21st 9 2018. Okay. The second form G came to be issued on 24 August 2018. Second form G. First one on 9 July. Which required the resolution plans to be submitted on or after 28th September 2018. Now the third form G come to be issued on 28th September 2018, which required the resolution plan to be submitted on or before 25/10/2018. तीन resolution plan हुए थे. फर्स्ट, सेकेंड, थर्ड. थर्ड कब तक करना था सबमिट? आपको 25 अक्टूबर तक. अब देखिए फोर्थ भी आ गया. ठीक है. Which have submitted to be on or before 13/12/2018. The fifth and the last form G come to the issued on 11/12/2018. और उसमें कब तक सबमिट करना था? 8 जनवरी तक करना था आपको. आपको 8 जनवरी तक उसका सबमिट करना था EY. ठीक है, सबमिट हुआ. इसमें NCLT ने उसे अप्रूव कर दिया. अब उसे प्रॉब्लम कहाँ है देखना पड़ेगा. NCLT ने अप्रूव किया, इसमें सारा लिखना पॉसिबल नहीं था बिकॉज 150 पेज का वो जजमेंट था. तो मैंने ब्रीफ लिखा है. आई विल एक्सप्लेन दिस. सो इसमें जो है, जो अपीलेंट है वो रीट पिटीशन फाइल किया उन्होंने मुंबई हाई कोर्ट में. मुंबई हाई कोर्ट ने कहा कि ये हमारे पास चैलेंजेबल नहीं है बिकॉज आपके पास अनदर ऑप्शन है, आपके पास अल्टरनेट ऑप्शन है, आपको इसका लीगल रेमेडीज है आपके पास. आप एनक्लेट पे जाइए. एनक्लेट में गए वो लोग, चैलेंज किया इसका अप्रूवल का. तो एनक्लेट ने कहा लिमिटेशंस के इसके लिए वो ऑब्जेक्शन किया गया कि लिमिटेशंस इसका एक्सपायर हो गया है. तो लिमिटेशन पीरियड 30 डेज होता है वो. तो एनक्लेट ने एक्सेप्ट कर लिया और उसको मेरिट में जजमेंट किया कि आप जो है दोबारा इसको ये कराइए, अप्रूवल लीजिए. he डायरेक्ट्स एनक्लेव ने डायरेक्ट किया CoC को कि आप इसको दोबारा अप्रूवल लीजिए, इसका सेकेंड अप्रूवल लीजिए दोबारा से। तो जो एपिलियंट जो है वो गए सुप्रीम कोर्ट में। नाउ द पिक्चर कम्स इन फॉर सुप्रीम कोर्ट। तो यह इशू दो था, एक तो लिमिटेशन पीरियड का इशू था जो कि खत्म हो गया था, लिमिटेशन पीरियड, और दूसरा इशू ये आ रहा था कि वो क्या जो एनक्लेव ने कहा था कि आप वापस इसको CoC दोबारा मीटिंग बुलाइए और इसको सेकंड दोबारा अप्रूव कीजिए इसको। तो क्या वो लीगली सही था या नहीं था? नाउ हियर वे now the picture comes for enclave. Kirby Data Management System Limited submitted their resolution plan on the last date as stipulated in the last and fifth form G. मतलब जो कर्बी डाटा मैनेजमेंट सिस्टम था, उन्होंने लास्ट डेट के बाद में सबमिट किया था उसको, डेट बीत जाने के बाद उन्होंने सबमिट किया था। हम आगे बढ़ते इस पर। On the other applicant, YEP Solution Limited submits its resolution plan jointly with one Satya Real Estate Private Limited. दोनों jointly किए थे उन्होंने किया 13th January 2019 को किया था उन्होंने। After CoC had approved the plan of Kalpraj RP, applied for approval of the plan before NCLT on 18 February 2019. ठीक है, अब आते सुप्रीम कोर्ट। सुप्रीम कोर्ट ने क्या कहा था? We have already held that the decision of enclave decision जो था 5 August 2020 does not extend the scrutiny of law it. आपने ये नहीं कहा कि लीगली क्या है, आपने डायरेक्शन दे दिया कि आप दोबारा भी मीटिंग करिए। This was not under the law, but under direction of एनक्लेव। एनक्लेव ने कहा कि दोबारा मीटिंग कराइए, इस कारण से दोबारा मीटिंग हुआ। मतलब कि जो मीटिंग was not as per the requirement of the act, but as per the direction of the act हुआ। सेकेंड मीटिंग हुआ उनका, और सेकेंड मीटिंग में जो अप्रूव हुआ प्लान, उसे फिर दोबारा NCLT ने अप्रूव किया, तो that was challengeable. So now it must follow that the subsequent approval of the resolution plan of KIAL by CoC become non-est in law, because it was not done through the legal process. It was through the direction of the enclave. For it was only to abide by the direction of enclave. सुप्रीम कोर्ट ने कहा कि जो सेकेंड जो अप्रूवल हुआ था वो आपका नहीं माना जाएगा उसको, not as per the law. The decision of the CoC dated 13-14 February 2019 is a decision which has been taken in exercise of its commercial wisdom. As such, we hold that the decision taken by CoC dated 13-14 February 2019, which is taken in accordance with its commercial wisdom and which is duly approved by NCLT, will prevail over enclave. And enclave was not justified in interfering with the stated decision taken by CoC. Means regulatory authority means or legal authority like NCLT or enclave cannot interfere the कमर्शियल विजडम ऑफ द CoC। मतलब आपके आपके फर्स्ट मीटिंग हुआ, वैलिड मीटिंग था, सब कुछ ठीक था। अब आप इंक्लेट करें कि सेकंड मीटिंग बुलाइए, वाई? अब सेकंड मीटिंग क्यों बुलाया जाए उसमें? सो यहां से स्टार्ट होता है कि कमर्शियल विजडम क्या सही है, क्या गलत है। और यहाँ से वो सिविल अपील उनका एक्सेप्ट हो गया और फर्स्ट मीटिंग वाज वैलिड एंड it was established that court cannot interfere with the commercial wisdom of CoC. The commercial wisdom of CoC has been given paramount status without any judicial intervention for ensuring completion of the stated processes within the timeliness prescribed by the Insolvency and Bankruptcy Code. In equivocal terms, held that there is an intrinsic assumption that financial creditors are fully informed about the viability of the corporate debtor and feasibility of the proposed resolution plan. मतलब CoC को सब पता है, जो प्लान उनके पास RP पुट करता है। Whenever RP puts the plan to the CoC, it was supposed that CoC has the knowledge of all this financial viability and what is requirement of CD, etc. We cannot say that CoC को पता ही नहीं है, CoC बेवकूफ है. This is not, you can say. They act on the basis of thorough examination of the proposed resolution plan and assessment made by their team of expert. मतलब जो CoC होती है उनके पास टीम होती है, एक्सपर्ट टीम होती है. You cannot say कि CoC को पता ही नहीं था क्या है, उन्होंने ऐसे बस लड़ाई झगड़ा कर दिया, ऑब्जेक्शन कर दिया. So this you cannot say that CoC have no knowledge or they have no idea about what is the process of IBC or how the resolution plan can be sustained or implemented in financial term, in legal term, and every aspect. So we assume that CoC has a full knowledge about, and they have full team of legal experts and other experts. So it has been held in Company Appeal number 503, 505, 529, 545, and 650 of 2021 that the opinion expressed by CoC after due deliberations in the meeting through voting as per voting shares is a collective business decision. मतलब कि जो भी CoC निर्णय ले रहा है उनका अपना डिसीजन है और we suppose that they have gone through all the requirement of the act and the company viability and financial feasibilities. So जब एक बार जो RP की ड्यूटी होती है, RP की ड्यूटी होती है कि वो रिजोल्यूशन प्लान मंगाए, उसे चेक करे, उसे पहले खुद देखे टेक्निकली, फाइनेंशियली, वायबिलिटी के हिसाब से भी, और अगर सब सही है तो आप पुट करें उसे CoC में. एक बार CoC में जाता है तो now this is part of CoC to put all aspect of either technical or financials or all viability of the and feasibility of the company requirement. Now it has been held that the legislature has consciously not provided any ground to challenge the commercial wisdom of the individual finance creditors or their collective decision before the adjudicating authority, and decision of the committee of creditors is the feasibility and viability of a resolution plan. No. Means अब देखिए यहाँ पे क्या है. हमारे आईबीसी को कोई चैलेंज करे सोप ही नहीं बचता सीओसी। दैट इज कॉल्ड हियर। अब कुछ इनका कहना है कुछ तो रीजन होगा कि उन्होंने कमर्शियल सीओसी को सुप्रीम माना है। सीओसी को अगर सारा राइट दे रखा है, यू कैन नॉट चैलेंज द विजडम सीओसी, कुछ तो कारण होगा। The court held that what is left to the majority of decisions of the committee of creditors is the feasibility and viability of a resolution plan, which obviously takes into account of all aspects of the plan, including the manner of distribution of funds among the various classes of creditors. ऐसा नहीं कि आप बस स्कूल पेपर देखे हो गया, उन्होंने सारा चीज डिस्कस किया होगा आपस में कलेक्टिवली, ईच एंड एवरी क्रिएटर्स डिस्कस किए होंगे। हाउ कैन we collect funds, how can we use funds, how can we share funds, how can we go for the revival of the company and sustain the basic motive and basic vision of the company. So all things must be discussed in CoC meeting. That is supposed by the law and the court. As an example, take the case of the resolution plan which does not provide for payment of electricity dues. If our resolution plan does not provide the payment of electricity dues, it is certainly open to the committee of creditors to suggest a modification of the prospective resolution obligate. भाई आपने क्यों नहीं किया इस पे? बिजली का तो आपने प्रोविजन नहीं दिया इसमें, तो they can comment on this. Such dues out to be paid in full. तो वो उसको वापस कर सकते हैं कि आप दूसरा प्लान दीजिए आप, so that the carrying on the business of the corporate debtor does not become impossible for want of most basic and essential elements for the carrying on of such business. अब बिजली नहीं रहेगा तो कैसे कंपनी चलाएंगे हम? बेसिक नीड है ना, ये तो एमिनिटीज है। तो सीओसी बोल सकती है या तो आप प्लान वापस लीजिए, रिजेक्ट कर सकती है, या फिर मौका देगी उनको कि आप इस प्रोविजन डालिए, इसमें आपने बिजली का प्रोविजन डाला ही नहीं आपने। तो दिस इज जस्ट अ स्मॉल एग्जांपल लाइक दिस। कुछ ऐसा चीजें हैं जिससे हम आगे कंपनी चला ही नहीं सकते हैं। दिस में in turn be accepted by the resolution creditor, resolution applicant, with a consequent modification as to distribution of funds. मैंने ऑलरेडी बताया कि उनको मौका दिया जाएगा, भाई आप इस पे करिए, इस पे मॉडिफिकेशन कीजिए इसमें। Payment being provided to a certain type of operational creditors, namely the electricity distribution company, out of upfront payment offered by the proposed resolution applicant, which may also result in a consequent reduction of amounts payable to the other financial and operational creditors. देखिए उसमें आपको पता है कि वो सीरीज ऑफ वो ड्यूज है, कैसे कैसे पे करते हैं, डिस्ट्रीब्यूशन रूल है हमारा। लेकिन उसमें एक ऐसा डिस्ट्रीब्यूशन रूल है जिसमें जो हमारे लिए एसेंशियल सर्विसेज है, अब उसमें बिजली का सबसे नीचे आता है, पता है आपको। जो ऑपरेशनल क्रेडिटर्स का ड्यूज होते हैं या गवर्नमेंट ड्यूज होते हैं लास्ट में आते हैं, बाद में आते हैं। लेकिन ये इसके बिना कंपनी चल नहीं सकती है। तो फिर हम क्या कर, सीओसी क्या करेगी, कहेगी आप मॉडिफाई करिए और इस पे इलेक्ट्रिसिटी का प्रोविजन डालिए, बिकॉज विदाउट इलेक्ट्रिसिटी वी कैन नॉट रन द बिजनेस। What is important is that it is the commercial wisdom of all the majority of creditors which is to company appeal number 503, 505, 529, 545, 650, determine through negotiation with the prospective resolution applicant as to how and in what manner the corporate resolution process is to take place. Means this is part of their commercial wisdom of CoC to determine that what financial planning needs for the effective run of the CD business. It is also submitted that similarly in the Insolvency Law Committee report 2018, आप लोग सबको पता है कि चेंजेस हुए हैं 2018 के बाद पार्लियामेंट में गए हैं और अमेंडमेंट एक्ट भी पास हुआ है IBC का. It was re-emphasized that the objective of the code is to respect the commercial wisdom of the CoC. CoC को सुप्रीम माना गया है because after all बेन सब सारा ड्रामा CoC के लिए हो रहा है. आप क्या करना है, आपको CoC के लिए पैसे कर रहे हैं ना, उसको रिवाइवल कैसे हो, कंपनी कैसे अच्छे चले, पेशेंट मैनेजमेंट हो, ऑल फॉर द CoC. CoC कुछ तो राइट होगा ना भाई. CoC का राइट ही छीन लेगा तो फिर मेन मोटिव ही खत्म हो जाएगा कंपनी का ना. जब हम कमर्शियल विजडम ऑफ CoC ही नहीं रहेगा तो क्या बचेगा. तो the Honorable Supreme Court in case already explained earlier, case Asadhar, and further affirmed that the CoC company appeal of means commercial wisdom is paramount. Commercial wisdom is paramount. Thus, if the CoC is in its commercial wisdom considers it appropriate to have a interest of all stakeholders and public money. No. It appropriate to have a reconsideration of its decision. The appellant tribunal may consider the same and remand the matter back to in the larger interest of all stakeholder and public money. मतलब CoC बोल सकते हैं कि हम इसको दोबारा देखना चाहते हैं, तो वो ऐसा नहीं कि आप नहीं एक बार हमने पास कर दिया, कैसे देख लेंगे आप. देख कब वापस भेज सकते, ठीक है आप दोबारा देख लीजिए. इससे अच्छा अगर आपके पास प्लान प्रपोजल है वो लाइए आप. Okay. SG has also stated that without prejudice, CoC has the power to approve, audit, reconsider a plan. And it includes rejection also. I am reading this. It includes rejection also. It may reject also. It is right that the power to do also includes power to undo. It has been time and again observed by the courts in India that the power to make an order includes power to aid or amend. आप एक बार कर लिए, डिसीजन ले लिए, तो कल लगता है कि आपको इससे अच्छा हो सकता था, तो ये भी राइट है आपको. नहीं आप कोर्ट से बोलिए कि नहीं हम एक बार चांस दीजिए हमें, मे भी इससे अच्छा प्लान लाएंगे, हम इससे अच्छा और बढ़िया प्लान होगा हमारे पास. Amend, vary or rescind the said order as well. So, recognizing the inherent right, the Honorable Supreme Court too, in the case of Kamlesh Kumar Ishwar Das Patel versus Union of India, had observed that the authority making the decision can also revoke it. Revoke कर सकते हैं वो लोग, amend, revoke भी कर सकते हैं. कुछ केसेस हैं इसमें, लीडिंग केसेस हैं जो कि हम डिस्कस कर सकते हैं वन टू वन करके. फर्स्ट केस आया था MK राजगोपालाचारी वर्सेस डॉक्टर पेरिस्वामी गौंडर का. इसमें उसके बाद इस केस में क्या हुआ था कि this case illustrates that judicial review is necessary to ensure compliance with legal standards and to balance the CoC discretion with accountability. देखिए हमें डिस्कस कर रहे हैं कमर्शियल विजडम ऑफ CoC का कमर्शियल विजडम में इंटरफेयर नहीं करना है, लेकिन ये तो देख सकते हैं हम ना कि अगर कोई प्लान सीओसी पास कर रहा है, जैसे वीडियो कॉल हुआ था, आप 99% हेयर कट कर दे रहे हैं, 96% हेयर कट कर दे रहे हैं फाइनेंस क्रिएटर का, तो आपने क्या टेक्निकल सारा क्राइटेरिया फुलफिल किया कि नहीं? क्या आपने जो प्रोसेस हुआ था आईबीसी का फॉलो किया कि नहीं आपने? उसके बाद जो कोई कंप्लायंसेस थे, आपने जो फॉर्म जी आपने किया, फॉर्म जी को प्रॉपर ढंग से आपने पब्लिश किया कि नहीं? उसका रिजल्ट एप्लीकेंट कितने आए आपके पास? मतलब दे ऑलवेज सब्जेक्ट टू रिव्यू, ये भी नहीं कि आप रिव्यू नहीं कर सकते उसको। लीगल स्टैंडर्ड्स क्या है उसका, सीओसी का बैलेंस क्या है, सीओसी ने किसने अप्रूव किया किसने नहीं किया है, ये भी मैटर करता है। अकाउंटेबल कितना आप है, आपकी इंटीग्रिटी भी देखी जाएगी वहां पे। तो सिर्फ कमर्शियल विजडम जो है, राइट है उनको अप्रूव करने का, रिजेक्ट करने का, वो छोड़ के बाकी सबको स्क्रूटनी कर सकते हैं। ये केस था हमारे एम के राजगोपालाचारी वर्सेस डॉक्टर पिरस्वामी गाउंडर का। अब एक और केस आया, के शशिधर वर्सेस इंडियन ओवरसीज बैंक एंड अदर्स। इसमें कहा गया कि देखिए, जो कमर्शियल डिसीजन है कि प्लान को अप्रूव करना है या नहीं करना है, ऑलरेडी हमने कहा आपसे, और इसको एमेंड करना है या रिवोक करना है अपने अपने ही प्लान को, ये और दिस अंडर एम्बिट ऑफ सीओसी, दिस इज ओनली सीओसी राइट। आप उस पर डिपेंड नहीं कर सकते हैं, बाकी आप कहीं करिए, आप उस पर स्क्रूटनी नहीं कर सकते आप। तो देयर इज अ थिन लाइन, बाउंड्री लाइन है हमारे पास कि कहाँ पे हम कर सकते हैं, क्या कर सकते हैं, क्या नहीं कर सकते हैं। सो दिस इज मेन थिंग, सीओसी की किस एक्ट को हम चैलेंज कर सकते हैं, रिव्यू कर सकते हैं और कैसे कर सकते हैं, ये भी है। पहला, अगर अगर सीओ लगता है डबल ए को कि सीओसी ने कहीं और मतलब बेटर प्लान ला सकते थे, तो उनको डायरेक्ट कर सकते हैं कि आप इसको इससे बेटर प्लान लाइए, या लेकिन आप ये नहीं कर सकते कि आप उसके अप्रूवल को चैलेंज कीजिएगा। तो ऑल दिस अंडर रिकमेंडेटरी नेचर, सीओसी चाहे तो नहीं भी ला सकता है। आपको टेक्निकल अगर कोई कमी है तो आप उसको ये कर सकते हैं कि आप उसको दूर करके दोबारा पास कर लाइए, लेकिन ये नहीं करेगा कि आप टेक्निकल दूर करके अपने आप पास कर दे रहे वाले। डबल ए कभी अवॉइड नहीं कर सकते कोई भी लीगल। अब एक और केस आ रहा है, प्रताप टेक्नोक्रेट्स प्राइवेट लिमिटेड वर्सेस मॉनिटरिंग कमेटी ऑफ रिलायंस इंफ्राटेल लिमिटेड। इसमें वही कहा गया है कि सुप्रीम कोर्ट ऑब्जर्व दैट the CoC has the domain to deal with the entire data of the corporate data। ये CoC का डोमेन एरिया है और आपको इंडिपेंड नहीं करना है इसमें। जयंत बनर्जी वर्सेस शशि अग्रवाल का केस था, इसमें एनक्लेट किया था, डिसीजन दिया था। इसमें यह कहा गया था कि आपका जो रिक्वायरमेंट है, स्टैट्यूटरी रिक्वायरमेंट है, उस पर एक्ट में पढ़ेंगे हम लोग, अदर से दिया गया है कि आपका अगर रिजल्ट प्लान नहीं आ रहा है तो आप कर सकते हैं कि कंपनी को आप ये रिकमेंड कर सकते हैं, कंपनी को रिकमेंड इसके लिए, लिक्विडेशन के लिए। द सीओसी कैन रिकमेंड द company to be liquidated if there is no proper resolution plan received, but 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 in that case we have to follow all of the statutory requirement before liquidating the company. And the foremost one thing is that we have to provide the plan where we can meet the expenses of liquidations. How can we provide the liquidation expenses? Okay, and all other plan. The CoC has unrestricted discretion to make decision under the principle of commercial wisdom. However, the creators have the right to challenge the CoC's administrative actions if they believe the administrator's conduct has harmed the creator's interest. They can challenge the decision-making process. CoC जो decide किया तो उसमें में भी कमी हो सकती है, तो they can challenge and NCLT can ask the CoC to review this. Now we have a leading case of Ram Krishna Forging Limited versus Ravindra Lunkar resolution process. थोड़ा सा अलग हटके है ये CoC, लेकिन बोरिंग नहीं है अगर आप लोग पार्टिसिपेट करें तो। बहुत क्रूशियल है CoC है। कमर्शियल विजडम CoC को समझना बहुत इंपॉर्टेंट है, बिकॉज एक बहुत पतला लाइन है, इट्स अ वेरी थिन लाइन, जो कि डिफरेंस करता है अदर डिसीजन मेकिंग एंड कमर्शियल विजडम। कहाँ हम चैलेंज कर सकते हैं, कहाँ नहीं कर सकते हैं, कैसे कर सकते हैं। जब तक इसको समझेगा नहीं तब तक CoC फिर वो कुछ भी करे, हम तो कुछ कर ही नहीं सकते फिर। और पायनियर में हुआ था, ऐसे ही हुआ था। पायनियर में CoC ने जो फॉरेंसिक रिपोर्ट आई थी, मैं आउट ऑफ द वे बात कर रहा हूँ, तो जो फॉरेंसिक रिपोर्ट आई थी उसमें यह आया था कि जो CoC का जो मेन member of CoC is also involving in that part, that the role have some financial, उनको पता था फाइनेंशियल कुछ हुआ है, मतलब गड़बड़ हुआ है, लेकिन there is no scope for the challenging of the, we have no knowledge, we had no knowledge about how can we challenge the decision of the CoC at the court. Anyway, तो यहाँ पे जानना बहुत जरूरी है कि हम कहाँ चैलेंज कर सकते हैं CoC के डिसीजन को, और CoC का बस क्या पावर है और क्या लिमिटेशंस है यहाँ पे, बिकॉज CoC's पावर इज नॉट एब्सोल्यूट। ऑलरेडी मैंने काफी बताया आप लोगों को कहाँ का चैलेंज कैसे कर सकते हैं, और कोर्ट की क्या लिमिटेशंस होते हैं ये भी देखा है हमने। So now here we come for the case of Ramakrishna Forging Limited versus Ravindra Lunar. अब ये बताइए कि CoC में हमारे से ही लोग होते हैं, लेंडर होते हैं, और उनका मेन पर्पस होता है इन इंडिया, आई डोंट नो अबाउट फॉरेन वर्ल्ड, उनका मेन पर्पस ये होता है कि हम पैसे रिकवरी करें पैसे को। तो उसके लिए वो सोचेंगे, गवर्नमेंट चाहती है कि वो कंपनी को रिवाइवल मोड में रखें, हम लिक्विडेट नहीं होने दें कंपनी को, और CoC का एक ही काम होता है पैसे लेना, कैसे भी पैसे हमारे रिकवर हो। एनीवे, तो इसलिए we have various regulations for that. मेरे केस में CoC मीटिंग होती थी फॉर लाफिंग, मतलब फॉर जोक, और वो आप जो CD थे और जो आपके जो फाइनेंशियल क्रिएटर्स थे, वो बस यही बात करते थे कि हमें सेटलमेंट कैसे हमारा हो, कैसे कौन सी उसी टर्म बात करते थे। मैं बोलता भाई मैं भी बीच में हूँ, मुझे मेरे भी रेगुलेशंस है, तुम लोग आपस में डील बात कर लोगे तो रेगुलेशंस कहाँ जाएगा IBC का। अल्टीमेटली सेटलमेंट हो गया, ठीक है, दैट इज वेरी गुड थिंग, एंड NCL also want the matter should be settled, बट मतलब CD चाहता है कि हमारा कंपनी ये मुक्त हो जाए IBC से, CIRP से, और CoC क्या चाहता है कि हमारे पैसे मिल जाए, सेटलमेंट हो जाए, एप्लीकेंट चाहता है पैसे मिल जाए। सो the basic purpose is not to the recovery of amount. IBC is not meant for the recovery of amount. This is not a forum for the recovery of amount. But this is the forum to lead the efficient management ultimately and go through the right hand of the financial creator. Anyway, So in this case, a CILP was initiated against ACIL Limited. ठीक है, इनिशिएट किए एप्लीकेंट होंगे, एप्लीकेंट आईडीबीआई बैंक है। आईडीबीआई बैंक ने अप्लाई किया, एप्लीकेशन फाइल किया एनसीएलटी में, ऑब्वियसली एनसीएलटी में होता है। और किसके अगेंस्ट में? इट वाज ACIL लिमिटेड। ओके, द एपिलेंट सबमिटेड द फर्स्ट रेजोल्यूशन प्लान। अब यहाँ सीधे एपिलेंट पे आ जाते हैं, बाकी कहानी हुई होगी, जो कहानी हुई होगी, सीओसी बनी होगी, उसके बाद फॉर्म जी फाइल सबमिट किया गया होगा, रेजोल्यूशन प्लान आया होंगे। एनीवे, तो आफ्टर दैट जो रेजोल्यूशन एप्लीकेंट थे, द अपीलेंट, मतलब रेजोल्यूशन एप्लीकेंट नहीं, अपीलेंट एप्लीकेशन फाइल किया, अपील फाइल किया था। द अपीलेंट resolution applicant submitted the first resolution plan. पहला क्या था प्लान? अच्छी सर हम लोग ऑलरेडी डिटेल्स पढ़ रहे हैं इसका। हम लोग पहला प्लान था, उन्होंने 63.5 करोड़ लोन दिया उन्होंने। आफ्टर द पब्लिकेशन ऑफ एक्सप्रेशन ऑफ इंटरेस्ट बाय द RBI, after several negotiation, an addendum was submitted to the RP with a range of payment to the FCS 73 crore and 80 lakhs. Revised plan was submitted by the appellant and later on the final resolution plan was submitted. Okay. It further provided that the proceeds to a particular land will also go to the FC with 88.56% votes. CoC approved the plan. Plan approved हो गया. As per the procedure, the approval of plan was moved before the adjudicating authority. डबल है NCLT. कौन सेक्शन में गया था? Section 36 and 31 of the code. NCLT gave the order which led to abeyance of the resolution plan. NCLT ने ऑर्डर दिया कि इस प्लान को अभी रोक दिया जाए और directed to official liquidator to provide the exit value of the assets. यहाँ देखिए क्या हुआ यहाँ पे पावर ऑफ CoC का पावर था वैल्यू अपॉइंट करने का। NCLT ने उसको ओवरराइड करके और जो गवर्नमेंट का ओएल है उनको कहा कि आप इसको एक बार आप देखिए और वैल्यूएशन इसका दीजिए, फ्रेश वैल्यूएशन। In the appeal made under 61 of the code, enclave upheld the orders of NCLT. ठीक है। Thereafter, the appeal under section 62 of the code come into the place where the above said orders were challenged. अब इशू क्या आया यहाँ पे सुप्रीम कोर्ट में इशू आया कि whether the adjudicating authority have a right to go into the issues of re-evaluation while exercising its powers. Depending on the contentions provided, this fact is of now dispute that there was a clear approval of resolution plan by CoC for more than what is required. Hence, no impediments is observed on part of CoC. अब इसमें जजमेंट भी और सारा है इसमें. Several judgments were considered by the court, such as K. Sasidhar and Committee of Creditors of SR Steel India Limited, emphasizing on the points that the commercial wisdom is non-justificable. The commercial wisdom जो होता है वो is non-justificable. In addition, a reference was made to the judgment of किसका किया गया? कल्पराज, धर्मसी एंड जो ऑलरेडी हमने डिस्कस किया था, कोटक इन्वेस्टमेंट एडवाइजर लिमिटेड. stating that the enclave has its position as it doubted the merits of land approved with a majority of 84.36%. एनक्लेव ने डाउट किया जब 84.36% मेजोरिटी से अप्रूव हो गया, then how can we doubt? Another reference was made to the matter of Pratap Technocrats Private Limited versus Monetary Committee of Reliance Infratel Limited. अब इसमें क्या हुआ देखिए, wherein the court observed that the legislature in India has departed from the foreign insolvency regime as the former does not provide any ground for the review of commercial wisdom. मतलब जो फॉरेन कंट्री में होते हैं वहाँ पे, मैंने ऑलरेडी पहले बताया था, वहाँ पे कमर्शियल विजडम का ज्यादा यूज नहीं वहाँ पे. The judgment mentioned in the previous unit were also considered by the Supreme Court in determining that stricto sensu, it is now well settled that it is well within the CoC domain as to how to deal with the entire debt of the corporate debtor. This is the ambit and domain of the corporate debtor, CoC, to deal the debt of the corporate debtor. और वहां पे क्या होता है कि बहुत सारे नेगोशिएशन होते हैं, डिस्कशन होते हैं, ऐसा नहीं कि वोट फूट किया गया पास हो गया, तो वहां सेवरल नेगोशिएशन होते हैं और तब जाके फाइनल डिसीजन पास होते हैं. तो इसमें निर्णय ये आया कि द अपील वाज अलाउड, द ऑर्डर्स अंडर चैलेंज वर सेट aside by सुप्रीम कोर्ट एंड द सुप्रीम कोर्ट डिड नॉट रिमांड द प्लान बैक टू एनसीएलटी. ठीक है, प्लान वापस कर दिया. ठीक है, देखिए इसको. कौन सा केस था? अच्छा, let me take from the other thing. स्लाइड में नहीं है उसको. बहुत अच्छा केस था मेरे पास. We have various cases also here. Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Construction. इसमें वही कहा गया था कि the court in a commercial wisdom CoC is accepting or rejecting the resolution plan is paramount. और एक और केस था, द प्रताप टेक्नोलॉजी प्राइवेट लिमिटेड वर्सेस मॉनिटरिंग कमिटी ऑफ रिलायंस। इस पे भी एक आगे इंटायर डिसीजन मेकिंग इज लेफ्ट टू द CoC बेस्ड ऑन इट्स कमर्शियल विजडम। One of the grounds of appeal under section approved the resolution plan based on its commercial wisdom. इसमें क्या है कि the NCLT in declining to recognize the commercial wisdom of the CoC has acted in accordance with, ठीक है। एक और केस आया आपके पास, इंडिया रिसर्जेंस हेयर्स प्राइवेट लिमिटेड वर्सेस MS अमित मत्तालिका लिमिटेड। इसमें resolution plan such decision may be being essentially a business decision based on commercial wisdom। मतलब जो CoC का जो डिसीजन होता है वो कमर्शियल बिजनेस डिसीजन होता है। The resolution plan such decision being essentially a business decision based on commercial wisdom of the committee of creators. In this regard, the observations proposes for arriving at a business decision in exercising of commercial wisdom of the committee of creators cannot be subject to judicial review। देखिए क्लियर कट है कि आप जो है कमर्शियल विजडम CoC को रिव्यू नहीं कर सकते। बैंक ऑफ महाराष्ट्र वर्सेस वीडियोकॉन इंडस्ट्रीज लिमिटेड, बहुत लीडिंग केस था, सबको पता होगा। बैंक ऑफ महाराष्ट्र वर्सेस वीडियोकॉन इंडस्ट्रीज लिमिटेड। Aspects and falls within its exclusive domain and commercial wisdom of CoC and cannot be interfered। बैंक ऑफ महाराष्ट्र और वीडियोकॉन क्लियर कहा गया है। Such modification is not permissible। It is settled law that commercial wisdom of the CoC is paramount and cannot be assailed। कई सारे केसेस इस पे और भी केस है। रीजनल प्रोविडेंट फंड कमिश्नर वर्सेस आशीष रीजनल प्रोविडेंट फंड कमिश्नर वर्सेस आशीष चौहारिया एंड अनदर। इसमें क्या कहा गया था कि अपलेंट CoC in the commercial wisdom approved the resolution plan। However, while approving the resolution plan, the executive authority has not said anything। नेशनल कंपनी लॉ ट्रिब्यूनल, इसमें एक और केस था, यूनियन बैंक ऑफ इंडिया ऑन बिहाफ ऑफ द एंड मिस्टर कपिल वाधवान। Conditions are acceptable to the members of CoC in the commercial wisdom। Ultimately, it would benefit, देखिए यहाँ क्या आ रहा है, conditions are acceptable to the members of CoC in the commercial wisdom। Ultimately, it would benefit majority of financial creditors, bank, financial institutions, and thousands। Settled proposal is viable, feasible, and acceptable after exercising commercial wisdom of CoC। It would immensely benefit of the member of CoC and in turn would। Now other cases, Kotak Investment has already explained about this। Damodar Valley, how it come with all this case? Damodar Valley Corporation versus Kharkia Steels Private Limited and others। Payment over financial creditor, and when the CoC exercise its commercial wisdom to finalize the resolution plan for revival of the corporator, it must emphasize that the business decision taken in exercise of commercial wisdom company cannot be interfered unless creditors belonging to a different, मतलब मेनी केसेस है। मुझे ब्रेक लेते हैं 15 मिनट का, फिर हम लोग आते हैं सारा डिस्कस करें 1 to 1 इसको। तो अंजलि जी आर यू देयर?
Yes, sir.
Let us some a small break. I will
Yes,
come
sir.
come with all these cases with details.
Okay, sir.
Okay, thank you. So we'll join on 4:55. Is it okay?
Sure, sir.
Yes, sir.
Sure.
Thank you. केस खुला भूल
family stop. ऐसा What happened?
Just a break, coming in 2 minutes. Can we resume? Am I audible?
Yes, sir.
Am I audible?
Yes, sir.
Actually, we come with a very good case, and this is actual order of Supreme Court. And the case is case Sasidhar versus Indian Overseas Bank. Now we start from the fact of the case. The NCLAT NCLAT affirmed the order passed by the NCLT Mumbai bench. Okay. रिकॉर्डिंग रिजेक्शन ऑफ द नाउ अब यहाँ पे रिजेक्शन की बात करेंगे हम लोग अभी तक अप्रूवल की बात कर रहे थे रिजेक्शन की बात हो रही है यहाँ पे रिकॉर्डिंग रिजेक्शन ऑफ द रेजोल्यूशन प्लान concerning IIL and directing initiating of liquidation process under chapter 3 of part 2 of INB code मतलब कि जो उन्होंने पास किया था CoC ने CoC has passed those resolution plan the NCLT as well as NCLAT has rejected that plan and ordered for initiation of liquidation process. The NCLAT held that, as in both the cases, the resolution plan did not garner support of not less than 70. Earlier it was 75%. Now it is 66%. So it was before the amendment of 2018. So The enclave held that as in both the cases, इसमें मैं थोड़ा ब्रीफ कर दूं आप लोगों को. इसमें क्या हुआ था कि उन्होंने ये कहा था कि 75% means 75% of vote attended. Those who are absent from the voting will not be counting as a voter. So if we exclude the person not attended the voting process, our ratio will be percentage of voting will be 80 plus 83%. So accordingly, it is more than 75%. But the enclave held that, as in both the cases, the resolution plan did not garner support of not less than 75% of voting share of the financial creditors, constituting the Committee of Creditors, CoC. The same stood rejected and thereby warranted initiation of liquidation process of the concerned corporate debtor. Debtor क्या नाम था? KS and PIPL and IIL. For considering the grounds of challenge in the respective appeals, we deem it appropriate to advert to the relevant facts concerning the respective corporate debtor. Now, this is the fact. We are not going for that. It's not our. Higher appointed is constituted. This is also not our part. Now come for this. In the third meeting of CoC, convened on 12th May 2017, the corporate debtor made a presentation for a resolution plan, giving 3 options. In that meeting, it was resolved to appoint SBI Capital Markets Limited to determine the sustainable debt of the corporate debtor, to enable the creditors to assess the viability of the resolution plan. Third meeting हो गया. In the fourth meeting of CoC, कब हुआ था ये? 27 जून को हुआ था. 17. The resolution plan submitted by the corporate debtor was reviewed in that meeting, and the draft techno-economic viability reports by SBI Capital Markets Limited was also considered. It is not necessary to delay on other aspects discussed and resolved in this meeting. As the statutory period of 180 days for completion of CIP was to expire, an application was filed before the NCLT Hyderabad for it is also not our part. The sixth meeting of CoC was held on 24th August 2017. When the corporate debtor submitted an expression of interest from Area Group of Companies, Chandigarh, to infuse rupees 150 crore in the form of debenture. Debenture के फॉर्म में उससे पैसा डाला गया, मांगा गया. Subject to getting a form approval from the lenders. The said proposal was circulated during the meeting, which concluded with the resolution that the same be placed along with the final report of SBI Capital Markets Limited. ठीक है, CoC में रखा गया, उसको रखा जाएगा मतलब. The seventh meeting of CoC was held on 26 September 2017. सातवां मीटिंग हुआ, in which various options were deliberated, but the discussion remained inconclusive. In the 8th CoC meeting held on 16th October 2017, 8वां मीटिंग हुआ, it was agreed that the resolution plan submitted by the corporate debtor should provide for monitoring and supervising by the resolution professional. In case the plan was approved by the CoC, ठीक है. The Indian Bank के पास कितना शेयर था? 22.33% शेयर थे इंडियन बैंक के पास. conveyed its disapproval to the proposal resolution plan. अब बताइए 22% से ऊपर वाले ने उन्होंने रिजेक्ट कर दिया इस प्लान को। अब इनके पास कितना बचा 77.2%। अब आगे देखिए JMFARC लिमिटेड हैविंग उनके पास शेयर कितना था 12.39% of voting power had already rejected the resolution plan। मतलब मीटिंग में उन्होंने रिजेक्ट किया और इन्होंने मीटिंग में नहीं किया। ध्यान दीजिएगा आप लोग, इंडियन बैंक के पास शेयर थे 22%, लेकिन उन्होंने मीटिंग के बाद रिजेक्ट किया और इन्होंने मीटिंग में रिजेक्ट किया था इन्होंने। Both these banks, however, agreed to reconsider the resolution plan if a portion of the sustainable debt was to be increased. The corporate debtor was asked to submit a fresh one-time settlement OTS proposal through email to all the bankers for consideration. Accordingly, the corporate debtor sent an email on 18th October 2017 with another OTS scheme proposal as an alternative to the resolution plan already submitted. The corporate debtors offered an OTS scheme proposal of rupees 525 crore with a structured repayment period indicated therein. ठीक है, इसमें आगे बढ़ते हैं इसमें। ठीक है, प्रॉब्लम कहाँ है बता रहे हैं आप लोगों को। अब यहाँ ये The proposal submitted by the corporate debtor on 26 October 2017 was approved by the members of the CoC having only 55.73% voting share. और जो मेन कंपनी इंडियन बैंक थे और जेम फाइनेंशियल, इलाहाबाद बैंक, आंध्रा बैंक, इंडियन ओवरसीज बैंक, वोटिंग शेयर कितने थे उनके पास 15.15%, rejected the resolution plan proposal and cited reason through its letter dated 27th October 2017. Three other banks, namely OBC, CBI and Bank of Maharashtra, उनके पास शेयर थे 29.12% voting share, expressed that they remained open, awaiting in principle approval from their respective sanctioning authority. Eventually, on 30th October 2017, OBC having 10.94% voting share sent an email conveying that their in principle approval to the proposed resolution plan co-revised OTS scheme and that their final approval vote would be subject to similar approvals from the co-lenders. On the same date, Bank of Maharashtra having 6.36% voting share conveyed that they were open to consider the revised resolution plan. The Central Bank of India having 11.82% voting share conveyed its disapproval to the revised resolution plan. Resultantly, as on 30th October 2017, the voting share of consenting banks expressly approving the proposed resolution plan was only 66.6%. मतलब फाइनल ये हुआ कि इनका जो वोटिंग जो अप्रूव हुआ वो रहा 66.67%। अभी तो ठीक है अभी के हिसाब से, लेकिन उस समय से हिसाब से गलत था। एंड डिसेंडिंग के पास कितना रहा 26.97%। तो अब जब अपील में गए ये लोग वहां पे, मैं ऐसे बताता हूँ आप लोगों को, जो अपील में वहां गए थे वहां पे एनक्लेट में, उस समय तक ये जो अमेंडमेंट आ गया था, जो अमेंडमेंट ऑफ 2018 का था वो आ गया था। वो आगे देखते हैं। The fact remains that the proposed resolution plan did not garner approval of not less than 75% at that time। उस समय था, अभी तो 66% हो गया है। Until the IRP filed an affidavit before the NCLT Hyderabad on 3rd November 2017, submitting the outcome of the 9th CoC meeting. Okay. The MD of corporate debtor appeared before the NCLT 6th November 2017 go, and also filed a memo on 17th November 2017 inter alia, submitting that for the financial creditor who choose not to participate in the voting, the votes and the majority be counted without their vote. मैंने ऑलरेडी बताया था ना कि आप जो एब्सेंट है उसको नहीं काउंट करें हम इस पे, ये बताया गया उस पे, मतलब for counting 75%, the absentee shareholders should be excluded. In that eventuality, the percentage of financial creditor who choose to participate and who approve of the resolution plan would work out for 78.63%, and therefore हो गया 50% से ऊपर. And it can be assumed that the resolution plan has been approved by the CoC. The NCLT by a judgment dated 27 November 2017 eventually allowed the petition filed by the corporate debtor and approved the resolution plan revised OTS scheme. जो भी था approve कर दिया उन्होंने. As submitted by the resolution professional wide affidavit dated 3rd November 2017, and further declared that the moratorium imposed on 10th February 2017 ceased to have effect. हाँ, जब resolution plan approve हो गया तो moratorium cease हो गया. From the date of receipt of copy of the order, a further direction came to be issued that the corporate debtor shall reinstate all the employees who were on the rolls of company. Aggrieved by the said decision, 3 financial creditors who were part of the CoC, जो बैंक थे जो डिसेंड कर रहे थे, इंडियन ओवरसीज बैंक, सेंट्रल बैंक, बैंक ऑफ महाराष्ट्र, उन्होंने 61 के अंदर एनक्लेव चले गए वो लोग. उनका यही था कि डिस्पाइट द फैक्ट कि 75% से कम हमारे अप्रूवल मिला उनको, तभी उसको पास कर दिया गया. तो एमडी ने भी फाइल किया, अपील फाइल किया उन्होंने भी 61 में, जो एनसीएलटी के ऑब्जर्वेशन को भी किए सही है. तो एनक्लेव में इसको दोनों अपील को हर्ट किया गया, एक तो जो एमडी थे उनका और एक ये जो बैंक थे. It has been held that approval to be proposed a resolution plan by a vote of not less than 75% of voting share of the financial creditors was mandatory. It was not open to the executing authority to disregard the mandate of the CoC by adopting a convoluted approach. मतलब 75% मतलब overall है, यहाँ कहीं नहीं लिखा है, कंपनी पे लिखा है वहाँ पे, यहाँ नहीं लिखा है, एसेंटी डिसेंडिंग नहीं, जो 75% होता है जो ऑल के थ्रू होता है. इट वाज डिफरेंट फ्रॉम कंपनी एक्ट. तो इसको ये एनसीएलटी के लिए ओपन नहीं है कि इसको डिफरेंट वे मतलब व्यू करें उसके लिए. Convoluted approach. Against this decision, the managing director of the corporate debtor has filed an appeal at Supreme Court under Section 62. और वर्कर्स यूनियन फाइल किए, वर्कर्स यूनियन थे वो भी फाइल किए कि अगर हम लिक्विडेट कर रहे हैं कंपनी को तो ये अगेंस्ट इंटरेस्ट ऑफ वर्कर्स होगा. तो एक तो पब्लिक इंटरेस्ट में फाइल हुआ और एक फाइल हुआ कि आप जो है एनक्लेव का जो जजमेंट उसके अगेंस्ट फाइल हुआ. इसमें ये कहा गया था कि directing the Union of India to revive the corporate debtor and save it from liquidation by both management and through worker union, कि कंपनी को रिवाइवल करने दीजिए, बिकॉज बेसिक मोटिव जो हमारे ये IBC का है कि रिवाइवल ऑफ द कंपनी, एंड continue as going concern. हाई कोर्ट ने तो रीट रिजेक्ट कर दिया कि आपको अदर ग्राउंड से आपके पास वहां जाइए। ये इन्होंने किया था, ये वर्कर यूनियन ने किया था वहां पे। ये काम का नहीं है। So I have then filed an application on 12th October 2017 before the executing authority, praying for initiating liquidating process against IAL. The NCLT Mumbai, after considering the submission of both sides by other pronounced in court on 23rd November 2017 and delivered on 8 December 2017, directing for initiation of liquidation proceeding against the CD. I'm going through the main judgment part because there is a very lengthy judgment. Supreme Court judgment is a very lengthy judgment. This is very. It is admitted that this should have been taken into account by the enclave in reference to the. This is point. One submission also is that this should have been taken into account by the enclave in reference to the amended provision brought into the force during the pendency of the appeal. मतलब कि जिस समय अपील पेंडिंग था तब तक वो चेंज हो चुका था, आपका 75% का 66% पे आ चुका था। तो उन्होंने प्रे ये किया कि जब हमारा अपील पेंडिंग था तब तक वो जो है एक्ट चेंज हो गया था, और इसमें आपको इस जो नया जो एक्ट है उसके मतलब अनुसार आपको कंसिडर करना चाहिए। सो इसमें ये कहें कि उसको retrospective में लेके being a clarificatory amendment, the same would take effect retrospectively and is applicable where even to pending proceedings also. इसमें प्ली ये लिया गया था इसमें कि आपका जो पेंडिंग जो भी इस पे है पेंडिंग प्रोसेस है वो सारे पे लागू होना चाहिए जो अमेंडमेंट हुआ था ये। इसमें बहुत ही मतलब जजमेंट आया था उसमें कि उसमें ये कहा गया था उसमें, मैं देख रहा हूँ वो पॉइंट मिल जाए तो, कि जैसे कंपनी लॉ में होता है ना, कंपनी एक्ट में हमारे पास जो माइनॉरिटी शेयर होल्डर के लिए भी होता है हमारे पास स्कीम, ऑपरेशन एंड मिसमैनेजमेंट का होता है, वहाँ पे हम केस कर सकते हैं। लेकिन यहाँ पे आईबीसी में कोई स्कोप नहीं है, माइनॉरिटी का कोई स्कोप नहीं है। क्या माइनॉरिटी है तो आपके इंटरेस्ट सर्व किया जा रहा है या नहीं वो देखने के लिए ऐसा कोई लॉ नहीं है इसमें। तो ये नहीं आप माइनॉरिटी जा सकते वहाँ पे कि नहीं हमारा इंटरेस्ट इफेक्ट हो रहा है। आप 75% या जो भी 66% पास हो गया, दैट इज फाइनल। मैं वो ट्राई करता हूँ मिल जाए तो बराबर। 150 पेज का है तो बहुत मुश्किल है पढ़ना रीड करना। ये बहुत अच्छा जजमेंट है, इसको आप लोग पढ़ेंगे, मैं शेयर कर सकता हूँ आप लोग ऑलरेडी। तो इसमें बहुत सारा चीजों को लिया गया इसमें। An appeal from an order approving such plan is only on the limited grounds laid down in section 613. However, an appeal from an order rejecting a resolution plan would also lie under section 61. मैंने ऑलरेडी कहा था आप लोगों से ना कि अपील अप्रूवल के साथ राइट है, रिजेक्शन का भी राइट सेम राइट है यहाँ पे। It already the liquidation process gets initiated under section 33 if either no resolution plan is submitted within the time specified under section 12 or a resolution plan has been rejected by the AA, where the resolution plan proposal before confirmation of the decision of the committee of creditors to liquidate the corporate debtor, or where the resolution plan approved by the AA is contravened by the concerned corporate debtor. The expression descending financial creditors defined in Regulation 21F of the IBC regulation to mean the financial creditor who voted against the resolution plan approved by the committee. This definition came to the amended subsequently with effect. मतलब ये 1 जनवरी के बाद में आया ये amendment ये। To mean the financial creditor who voted against the resolution plan or abstained from voting for the resolution plan approved by the committee. The resolution plan was expressly rejected by not less than 25% of voting share of the financial creditor. In such case, the resolution proposal was under no obligation to submit the resolution plan under section 36 of the INB code AA. Instead, it was a case to be proceeded by the AA under section 33(1), that is for liquidation of the company. The resolution plan received approval of the only 66.57%. मैं ट्राई करता हूँ निकालने का वो। एक मिनट। देखिए यहाँ पर, and there is no alternate plan mooted before the expiry of the statute period, ठीक है। देखिए यहाँ पे डबल ए हैड नो अदर ऑप्शन टू इनिशिएट लिक्विडेशन, मतलब स्टार्ट करने के लिक्विडेशन प्रोसेस इनको। The legislator, यहाँ पॉइंट लिखिएगा, बहुत पॉइंट अच्छा पॉइंट है। The legislator has not endowed the double A with the jurisdiction or authority to analyze or evaluate the commercial decision of the CoC, much less to inquire into the justness of the rejection of the resolution plan by the dissenting financial creditors. From the legislative history and the background in which the IAB code has been enacted, it is noticed that a completely new approach has been adopted for speeding up the recovery of the debt due from the defaulting companies. In the new approach, there is a calm period followed by a swift resolution plan to be completed within 270 days. Besides the यहाँ देखिए पॉइंट देखिए आपको। The legislature consciously has not provided any ground to challenge the commercial wisdom of the individual financial creditor or their collective decision before the double A that is made non-justifiable. ये ऑलरेडी बताया हमने आप लोगों को। The power and functions of the board have been delineated in section 196 of the INB code. None of the specified functions of the board, directly or indirectly, pertain to regulating the manner in which the financial creditor ought to or ought not to be exercise their commercial wisdom of their body. कहीं भी नहीं है कि आपको commercial wisdom में क्या है क्या नहीं है, कहीं भी नहीं लिखा हुआ है सब। So plain meaning है commercial wisdom अभी तक तो absolute है ये. You cannot have other option to override the commercial decision of the company. So बहुत सारे केसेस हुए और मतलब ये बहुत स्कोप ऐसा है कि बहुत सारा अभी भी ओपन है एरिया स्टडी करने के लिए, और लर्निंग मेंबर को कुछ और पता हो तो बताएं, हमें शेयर करें. इट्स ओपन फॉर क्वेश्चन आंसर. Anybody can have a question? Or can share their experience also. We are waiting 2 minutes. for question answer. Anybody can ask question, or even share their experience, or can suggest something. Yes, Prabhujalji, if I want to share something. Anybody want to say something? You are muted. Please unmute
Yes,
yourself.
sir. I have no question, sir.
Okay, and Rajas, Doctor Sir.
No, sir.
Okay,
It was a good session. Nice.
Okay.
I tried.
Practical.
It's a very technical thing, and there is no
More
much
than a
scope from
technical,
that.
so it was a little, happening in that way only because there are a lot of cases as well you need to discuss.
Yeah, it's only it depends upon case law only, because
Yeah.
there's no much legislation process in IBC Act.
Yeah.
So that is why we can't do much apart from this.
Correct.
Yes, sir.
So, Anjali ji, thank you very much.
Thank you, sir.
Thank you very much, sir.
Thank you all participants, and Anjali ji particularly for giving me opportunity for presenting myself. Thank you all.
Thank you, sir.
Thank you very much, sir, for giving your time and taking session on the topic. The session was very wonderful. Sir, please share the PPT with us.
Sure, I'll share this. Thank you, everyone. Thank you very much.
Thank you, sir.
You have closed this session, Anjali ji? Anjali ji,
Sir?
you may close this session.
Yes, sir. Yes, sir.
Thank you.